Good afternoon. My name is Cameron McElhenney, and I serve as the Director of Training and Education for the National Association for Civilian Oversight of Law Enforcement. I would like to welcome you to NACOLE's 2019 webinar series, where today we will be discussing strategies for conducting interviews with officers. Before I turn things over to our presenters, I would like to go over a few things regarding today's program. During the webinar, all attendees will be in listen-only mode. However, as soon as we begin, you will have the ability to type in any questions you have for John and Jason. When we come to the question and answer portion of the webinar, your questions will be asked and answered as they have been received. During the webinar, you may also send any questions you might have for me as the webinar administrator, and I will answer your questions as quickly as possible. I should also note that each of you can access handouts provided by today's presenters. These handouts, including officer interview scripts, notification, and interview procedures from various oversight agencies around the United States, can be accessed via the GoToWebinar control panel that currently appears on your screen. At the conclusion of the webinar, each of you will be given the opportunity to complete a very brief survey on today's event. If you could please take a few moments to complete this survey, it will help us as we move forward with enhancing and expanding our webinar series. With our housekeeping duties out of the way, I would like to introduce you to today's presenter. John Alden is a police accountability attorney in the San Francisco Bay Area. John served as the managing attorney of the Independent Investigations Bureau in the San Francisco District Attorney's Office, a unit specializing in the investigation of officer-involved shootings, in-custody deaths, and other cases of potentially criminal officer conduct. He also worked in the Internal Affairs Division of the San Francisco Police Department and for the Department of Police Accountability, formerly known as the Office of Citizen Complaints. At both the Internal Affairs Division and the Department of Police Accountability, John worked on the investigation and prosecution of administrative disciplinary cases against San Francisco Police Department officers, among other accountability issues. Jason Wechter, a former member of NACOLE's Board of Directors, has worked as an investigator for over 35 years, including 19 years at the San Francisco Department of Police Accountability. Here, he conducted hundreds of officer-involved shootings, serious use of force, and biased police investigations. He also created the agency's new investigators training program. While serving on its board, he drafted NACOLE's qualification standards for oversight investigators and supervising investigators and its recommended training for board and commission members. Jason is the NACOLE Certified Practitioner of Oversight, a certified legal investigator, and a certified criminal defense investigator. And now I will turn today's webinar over to John Alden. John?
Good morning. Thanks for joining us for today's webinar. I'm John Alden, and I'll be talking to you a little bit about some advisements that we recommend you give at the beginning of interviews. I should say right at the beginning that some of the material I'm going to cover comes from case law or other legal authorities that you might want to become familiar with. I'm an attorney in California, so I'm only licensed to practice law here in California. So for those of you in other states, you should definitely make sure to talk to an attorney who's licensed in those states to figure out if there's some state law or local issues you should be aware of. And another thing I always make sure to mention is that while I might be describing some laws to you here, even if you are in California or anywhere else, you should make sure you talk to the legal advisors in your particular agency to make sure you're on the same page with them. And I'd be happy to chat with them if you think that's useful, but definitely make sure you touch base with them as well after you see this webinar today. So part one, interview advisements. We're going to talk a little bit about how you set the stage for the interview, the things that we recommend you say to the officer, understandings you reach with the officer before the interview even begins. These are all advisements that should be part of the interview record. If in your area you record the interview either by audio or video, which we certainly recommend, then you'd want to make sure these advisements are part of that recording. This is not a casual conversation you have before the interview. You could have that also, but this should definitely be a formal part of the interview process. Next slide, please. There are 4 categories of advisements, 4 broad groups that I would recommend that you think about using in all of your interviews. And in all four of these areas, I strongly recommend you spend some time thinking about what these advisements should look like, how you want to say them, what your answers might be to some typical questions you might get with regard to these advisements. In other words, put together a solid script for yourself and make sure it's the same every time you do these interviews. Over time, your script might improve, but as a general rule, you want to make sure you hit each and every one of these advisements the same way every time as much as you possibly can. There are four categories that I recommend you give, and I recommend you do them in this particular order. So I'll be describing them one by one in the same order. One is the right to having a representative, also known as the Weingarten right. In order to speak, sometimes people refer to a case called Garrity versus New Jersey for this purpose. We'll talk a little bit about that. Any state rules that might apply, and any local rules that are specific to your agency that you might want to talk about. Next slide. So that first set, the right to a representative, comes from a set of public employee rights that all public employees have. Every public employee, not just police officers, but other public employees, including public employees you might be interviewing from your same agency, have the right, the Weingarten right to have a representative with them. This comes from National Labor Relations Board decision some years ago. The citations further down in the slides for those of you who are attorneys want to look it up. But basically it says that if an employer is talking to a public employee about something that could potentially get that employee in trouble with the employer, could result in discipline, they have a right to have a representative. Now, normally that is a right that the employee gets to assert or bring up. I recommend you mention it at the beginning in addition to waiting for the employee, or in this case, the police officer, to bring it up. Some employers have a rule that they explicitly require advisements about this every time. Some don't. I think it's just a good practice one way or the other. So you should probably talk to your agency about whether they have a policy about whether they spontaneously mention the Weingarten right or not. I recommend that you do, because it just creates clarity about the fact that this officer has a representative, and I think that increases the chances that people looking at this interview later on are going to believe that you completed the interview in compliance with Weingarten, and also that the officer had every reason to be thoughtful about his or her answers, because after all, they had a representative with them. They had plenty of help in this process. So what is a representative? Next slide. A representative is often a union representative. It could be another police officer. It could be an attorney, but under Weingarten, it could be anyone. So unless you have some local rules that restrict what kind of representative the officer can pick, it really could be any kind of person. It could be a friend. It could be a priest. It could even be a spouse. It could be a relative. Weingarten mandates only one representative. You might have local rules that provide for more, but generally it's just one under this federal rule. I would say, though, that there's nothing in Weingarten that says that those representatives are there to answer the questions. The employee is supposed to answer them. The representative is just there to provide moral support, point out issues that the employee might not know to raise, and to advise the employee, say, during breaks or before or after the interview takes place. So you should make sure that it's still the employee, the police officer, who's answering the questions, even with the representative present. Next slide, please. So the second category of advisements we recommend that you give are in order to speak. Now, it's really important here we talk about what kind of order to speak you're using. And that's why I divide these into two categories: mandatory statements and compelled statements. So by mandatory, I mean that the police officer is required to come to the interview and answer the questions that you put to them as a condition of their employment. Usually there is a local rule or policy that requires that the officer come to speak to you. Perhaps you are a representative of Internal Affairs Division or a civilian oversight agency, or maybe part of a city attorney's office. In any event, in some way, you work for the employing agency, the city, the county, the locality that employs the officer. And that officer has been ordered either by a supervisor or by some general rule to come talk to you. The second category of orders to speak have to do with compelled interviews. Now, this is a technical term, a term of art we use to mean that the employee has said, hey, I'd rather not talk because of my Fifth Amendment right not to be incriminated. And you, the employer, have ordered them to speak anyways. This is a little surprising to people, both that the issue would come up in this interview and also that the employer can order the officer to speak anyways. And so that's the thing we should talk about next, Garrity versus New Jersey. Next slide, please. So there was a case some years ago called Garrity versus New Jersey, a U.S. Supreme Court case in which the issue of what do you do when an officer comes into a mandatory interview and asserts their Fifth Amendment right to remain silent in the same way that any other member of the public would. And the discussion in that case basically boils down to this as a practical matter. If a public employee like a police officer is mandated to come to an interview and they assert their Fifth Amendment right, they can do that. They're certainly allowed to say, hey, I assert my Fifth Amendment right, just like any other citizen would, and remain silent. But the employer still has the right to fire them if they do. And how does that get resolved? Well, the way it gets resolved is that the employer can still order the officer to speak, fire the officer if they don't. And if the officer does speak, that statement will not be used against the officer in a criminal prosecution. It'll still be used in your administrative case, but not criminally, in any case that a prosecutor like a district attorney or a U.S. attorney might bring. This rule, this compromise, if you will, between the Fifth Amendment right and the right of the employer to get information from their employee applies to all public employees who go to a mandatory interview and assert their Fifth Amendment right. Police officers are certainly one category. Anyone else who's a public employee also has the same protections described in Garrity and the same obligation to speak or be fired. So it could be that in some of your interviews, you might have someone that you're compelling in the way that you would an officer who is, say, maybe a civilian employee of the police department. That's known to happen. So I want you to be aware it applies to more than just police officers, but most of the time you'll see it happening with police officers. Next slide, please. So what exactly counts as a compelled or Garrity statement? Well, under Garrity, the officer does have to assert the Fifth Amendment right. There needs to be something that happens in the interview in which the officer says, I assert my Fifth Amendment right, or I assert my constitutional right to remain silent. There has to be some sort of specific invocation of the right. The employer then has the obligation, if they still want a statement, to explain that, okay, I heard you, I get that you asserted your Fifth Amendment right, but I'm ordering you to speak anyways. A consequence there is that once you see that conversation happen at the beginning of the interview, the officer's statement will not be available to prosecutors. A couple cases that talk about this are Castigar and Gwillem, which I've noted here. Full citations are at the end of the presentation. So criminal investigators and, like, say, the criminal side of an internal affairs division, as opposed to the administrative side, which you might be working on or working with, have to be very careful to keep these compelled statements out of their files. And frankly, so should you. When the U.S. Attorney's Office sometimes gets involved with police departments in order to do either a collaborative reform process or mandatory court-supervised reform of the police department, they will often check to see if agencies like ours are doing a good job of separating out these compelled statements from the rest of the criminal file, so that they don't have problems with the criminal prosecution from getting those compelled statements commingled with the rest. So it's important you have a real clear invocation, and that's why this should be one of the advisements in your script. You should be prepared to talk about this issue with the officer. Next slide. So how often are officers compelled? I know there is a concern in some agencies, and I'm told by US DOJ also, that officers should only be compelled over their Fifth Amendment right, invoking Garrity, only when it's absolutely necessary. And there are some other agencies that take a different position. They feel that it is best to not only mandate that the officer come in for an interview, but also compel them in almost all cases. So for example, in the Los Angeles Police Department, in fatal force cases like officer-involved shooting, it is the general practice of the police union in that city to instruct officers to always assert their Fifth Amendment rights in that category of cases. And so in those cases, statements from officers are virtually always mandated and compelled. I'm told in New York, compelled statements are also very common. In San Francisco, where Jason and I have worked in the past, in these administrative cases, they're generally rare, except in officer-involved shootings or other cases where there's some clear risk of criminal liability for the officer. So I think it's important that your agency have a conversation about whether cases are always compelled or only sometimes compelled. Clearly, the interviews are always going to be mandated as a condition of employment, but whether you choose to compel someone over their Fifth Amendment right or whether you even breach the issue in the beginning of the interview is something you should think about as a policy matter. For some agencies, particularly those in California, you might have a state or local rule that requires you to at least provide an advisement about whether there is a parallel criminal investigation or the risk of a parallel criminal investigation. In California, the Police Officers' Bill of Rights requires such an advisement early on, and once you give that advisement, most of the time you can anticipate an officer is probably going to assert their Fifth Amendment rights, and you'll need to go through a script about compelling their statement under Garrity. Next slide, please. Garrity statements are sometimes used in court in criminal cases. It's not common. This is a list of a few different ways they can be used. So it's important that you not say that no one will ever see the statement. So if officers follow up with questions like, well, does this mean you'll never ever give my compelled statement to anyone else after I invoke my Fifth Amendment rights? You might want to have a script that looks a little bit like this slide, walking through some ways in which the statement may still be used. Definitely get some local legal advice about this list. This is a solid list for California practice and federal practice. Might be quite different in your state. Next slide, please. So just to give you an idea, too, of how you talk about compelled statements, it's really important that the language you use in your script makes this issue crystal clear. If you look at the middle column here, you'll see some examples of language I've seen in other interviews that was an attempt to memorialize that the officer was asserting their Fifth Amendment right, but in my opinion, wasn't very successful. So one question that you'll see in the vague column here is, are you ready to proceed? This was really common in San Francisco some time ago. I think any third party reading this would have no idea that this question is referring to the Fifth Amendment right to remain silent, but for reasons not clear to me, a culture had developed around asking the question in this way, I think because some police officers didn't like explicitly asserting their rights. They felt like that's not something that an officer does, and so they wanted this coded, ready to proceed language instead. Don't do that. Similarly, vague invocations are you sure you want to talk to me today, or have you already had your criminal interview? None of these clearly articulate whether this is or is not a compelled statement. Good examples of situations where you would not need a compelled statement or you wouldn't expect a statement to be compelled are over here on the right. Witness officers, especially in cases that don't involve any potential criminal exposure, like a discourtesy case, for example, you're almost never going to see an invocation there. Expert witnesses and non-employees can't be compelled over their Fifth Amendment rights, so you're not going to see that there. And the complainants usually aren't either. If they're speaking to you, they're waiving their Fifth Amendment right. If they have one in the case, you can't compel the complainants to speak in this regard. So those are not going to be compelled statements either. On the far left, you'll see the situations where I think you're usually going to see, and probably ought to see, a compelled statement. Officers who are charged with a crime in that same case, the officer who explicitly invokes, even though you haven't maybe brought up the issue, say they stop the interview midway through and say, hey, I think I need to assert my Fifth Amendment rights here. That would be a compelled interview. And usually officer-involved shooting interviews or other fatal force cases. Next slide, please. So one of the things that you should think about in your organization is what are the things that you need to do on your end to make sure that the compulsion really is done according to local policy. Who makes the order in your organization? Does it have to come from the chief of police, or can you, as the investigator, do it? Get that worked out in advance and know which way that question is answered so that your script can reflect the correct order from the correct person. I would not recommend you ever second guess whether the invocation of the Fifth Amendment right is in response to actual criminal liability. You're never going to be able to figure that out. If someone actually wants to invoke, then you should let them. Don't try to argue with them about whether or not they actually have criminal liability. Sometimes you might get surprised with a witness officer who you think has no criminal liability invoking. They still can, so just roll with it and go through the compulsion process as best you can. Keep in mind that whether somebody makes a compelled statement doesn't really have anything to do with California's rule about criminal tolling. For those of you who practice in California, you'll remember that in our Peace Officer Bill of Rights, there's a 1-year statute of limitations for bringing an administrative case against the officer. This issue about compulsion doesn't make a difference on the 1-year tolling for a parallel criminal investigation. For those of you who aren't in California, you don't have to worry about that, but the Californians will know what I'm talking about there. Also keep in mind that you might not be allowed to use the fact that the officer made the statement under this duress because they're compelled as a credibility factor. In California, there's an evidence code section that prohibits that. So I think in California, it's best practice not to see the fact that the officer made a compelled statement as a reason to disbelieve them. Shouldn't make a difference in their credibility one way or another, at least in California. And at federal law, they do allow you to infer that the officer is not as trustworthy if they chose to assert the Fifth Amendment right. You should think carefully about what your local policy is going to be and about whether you have state law or local policy that affects that decision. Next slide, please. So these third and fourth categories are a little bit easier, I think, to deal with. You should make sure you talk to your legal advisor about whether there are any state rules that might trigger specific advisements you need to make. I recommend making these after you've cleared the air about whether this is a mandatory or a compelled interview. That's why I recommend these go third. They're usually fairly subtle issues, like by comparison, such as whether or not the officer has the right to make their own audio recording of the interview. In California, they do. In other states, they might not. Make sure you know those rules and explain them to the officer explicitly early in the interview. Next slide, please. In California, these are some examples of rules that we have under COBRA, California Government Code Section 3303 specifically lays out these rules. No lie detector tests, no harsh language. The interview has to occur at an hour when the member would normally work, etc. One of them that's especially interesting here is this one about Miranda that you see low on the list. That's my sort of shorthand for one needs to provide advisements about the officer's Fifth Amendment rights, even if they're not in custody. So IC means. So in California, we have this state law obligation to tell the officer that they retain a Fifth Amendment right, at which point they might invoke it, and then we'll have to have that Garrity conversation we talked about earlier, compelling them to speak. And for those of you who are Californians, you might have also seen the parallel California case of Liebarger versus City of Los Angeles that talks about that in California context as well. So you might have a state or local rule that requires you to tell the officer about the Fifth Amendment rights. Next slide, please. Local rules. Of course, you're going to have some kind of local rules. So it has been my experience that in most places, there is a collective bargaining agreement that says something about the disciplinary process, perhaps something about the right to bring a representative, or the right to bring a representative of the officer's choice. Or maybe there are rules in your collective bargaining agreement about how much notice you have to give the officer in advance of the interview, 10 days, a week, 2 days, and what material the officer might be entitled to see before the interview. Make sure you've read those over. Even if you're in a civilian oversight agency that is advisory to the police department's discipline process, you might still be subject to these rules, and you should make sure you've talked to not only your legal advisor for your agency, but also your human resources unit inside your city or county to figure out what other rules they might have for you. They'll probably know those bargaining agreements better than you will. Sometimes there are local civil service rules that talk about conditions for interviews, particularly time of day or length of interview sometimes shows up there. Also notice procedures, what kind of notice the person has to get, whether it's delivered by certified mail or handed over by a supervisor is sometimes detailed there. And also what information they might be entitled to see about the case before going in for the interview. So make sure you've complied with all of those rules. Next slide, please. You might have a local rule about the officer's requirement to be honest. In San Francisco, we call that Rule 21 of Department General Order 2.01, and we make sure to read that in each interview, right? Basically reminding the officer that if they lie or obfuscate or fail to be complete and truthful in their answers, they can be fired just for that. That lays an excellent foundation for showing both that the officer's statements are to be taken seriously and not lightly, that the officer should have known to be thorough and complete in their answers when they gave the answers. But also that's a great predicate in case the officer actually does lie to you. You can show that they were explicitly advised of the consequences of lying just moments before they uttered the lie. And so if you do have to bring a disciplinary case for lying, it'll be much stronger if you have this advisement in your script. Next slide, please. You might have officer rights that talk about, say, getting a copy of the police report or some other notice rule or timing rule. I recommend you have the officer explicitly confirm that those rules have been followed at the beginning of the interview, so if there isn't an argument later about it. If they tell you that there is a failure to comply with those rules, then you have an opportunity right then and there to fix that. And you should fix it right then and there before you proceed with the rest of the interview. Next slide, please. So this is a short summary that you might want to peek at later on to remind yourself of which of these advisements apply to whom. One of the reasons I provide this is that these advisements are all quite different from the advisements you're probably going to be giving to the complainant. And I want to give you a sense of confidence that, yeah, you're not giving any of these advisements to the complainant or other civilian witnesses, and for good reason. These advisements just don't apply. Be careful that if you are interviewing people who are civilian employees of the agency, perhaps they're witnesses to some of the events but weren't themselves the accused officers, you might still be giving some of these advisements, and you should be prepared to think carefully about what they are. And of course, you'll be giving all four of these in this order to the police officer. Next slide, please. These are some citations you can use to find the other cases we talked about. And with that, I'll turn it over to Jason. Thank you.
Thank you very much, John. So as Cami mentioned, there are examples of many of the things I'm going to be discussing in the handout materials, and the PowerPoint is also in the handout materials. I know there's a lot of information in it, and I may not cover all of it because we want to leave time for questions. So can we have the first slide, please? So one of the main issues you're going to confront as you approach officer interviews is deciding the sequence in which to interview officers. Who are you going to call in first, who will be second, and who will be last? So one of the considerations is are officers or the representatives likely to share information from the interviews? Questions asked, answers given. If they have a right to audio record, they can share the audio recordings. If they take handwritten notes, they can share those, so the officer can simply communicate their recollections. This becomes accentuated if the same representative is representing multiple officers, so you may want to consider, will there be different reps? If an officer does not have a right to a representative or a right to audio record, obviously there's less material for them to communicate. Another significant consideration is which officers are most likely or least likely to provide complete and truthful information. In other words, who's going to be your best informant and who's most likely to hold things close to the vest. So you may want to bring in the officers who are going to be most candid and expansive first. If you want to get unrehearsed answers to critical questions from multiple officers, you may want to consider interviewing them one after another on the same day in close sequence, back to back. So there's minimal opportunity for them to talk to one another about what they were asked or what answers they gave. Now, you can have gaps in interviews if it won't risk disclosing critical questions you want key officers to answer without foreknowledge or preparation. And this is particularly true if you want to have an ability to some time to assess the evidence before you move on to the next interview. Next slide, please. So preparing for the interview. And obviously you want to review and have ready all the laws, rules, policies, and procedures. You can refer to them. This enables you to ask in an informed manner about standard practice, what this officer has been trained to do, what is this officer's or this unit's past practice. And that allows you to assess why this incident did or did not conform to training or standard practice or past practice. This can reveal a pattern of not adhering to training or regulations. A very good example of this is the New York City Police Department, which had a long-standing prohibition against use of chokeholds. It was routinely violated. It was not enforced. No one was punished for it. Having an event timeline is helpful. You can use it to refresh the officer's recollection. If they don't know where in the scheme of events something fell, you will have that reference there, and also enables you to evaluate their credibility. Same is true of a matrix of evidence, including any prior statements that officer made. Enables you to identify and address inconsistencies. If you're going to show documents to the officer that are evidence, you want to have 2 copies, one to give the officer, one to retain. And obviously you want to make sure your equipment is tested and ready to go, particularly if you're going to be playing recordings. Next slide, please. So John touched on some of the obligations for information you need to provide to the officer in advance of the interview. One thing you want to do is communicate their obligation to bring and retain specific materials such as notes, reports, statements, photographs. You want to advise them not to discard any materials. In San Francisco, officers would take notes in a small notebook, and they'd routinely discard these when they were full. So if the complaint comes in a timely manner, you may want to quickly communicate to them that they are to retain any materials, such as their handwritten notes. It should also contain a warning against interfering with the investigation, perhaps by intentionally contacting the complainant or civilian witnesses. That could be perceived as retaliation or trying to dissuade someone from participating in the investigation. Obviously, the required details of the complaint in California, this would typically be provided only to named officers, that is, officers who are subject to discipline, and only the information that is absolutely required to provide. I recommend that do not provide more information than you are required to. And John already covered issues about officers' rights and involuntary statements of use immunity. Next slide, please. So now we're going to talk about the officer interview script. John mentioned this about delineating an officer's rights and responsibilities. It should contain some basic information, the date, time, location of the interview. If you're recording, you want to have each party present verbally identify themselves on the record. This is important if you're transcribing or for anyone listening to the recording to be able to know who's speaking. And then you want to have some non-threatening background questions about the officer, their rank, their current and past assignments, their duties, training, prior service in law enforcement, special expertise, their current shift and schedule. These are questions that are easily answered. They're non-threatening. They diffuse the officer's nervousness. They also give you an opportunity to observe the officer's baseline behavior when they're responding to questions that aren't stressful. Then you compare that later on to their answers and how their behavior, nonverbal behavior, when they're asking some more significant questions. Getting some information about their training and experience can also be relevant to getting a sense of their understanding of and conformance to rules and procedures. And then you just want to have some questions about the incident background. What was their assignment, their shift, their partner, their clothing and equipment on the day of the incident. Next slide, please. So as John mentioned, officers will often have a representative. In San Francisco, only officers accused of misconduct or subject to discipline had a right to have a representative present. The overriding component here is that the investigator controls the interview. It's a fact-finding interview. It is not a hearing or trial or deposition. So the interview script should set those rules. John talked about that. It's very important. Don't allow the representative to control or interfere with the interview. They should not be suggesting answers to the officer. They should not be repeatedly interrupting your questioning.
Jason, are you still with us? It appears that we've lost your audio. If I could ask for your patience, we will address this problem as quickly as possible. We'll be back with you in just a moment.
Do we have the next slide, please? The one that says officer structure and questioning. I think I somehow got muted there for a moment. My apologies.
Okay, glad to have you back, Jason. Thanks.
Sorry about that. So we'll talk a little about the interview structure and questioning. So you want to start out, as you typically would with any interview, asking for an expansive, open-ended narrative, saying something like, please don't leave anything out. I want to have a full understanding of what happened from your perspective. You follow this up with open-ended questions that are going to cover who, what, where, when, why, and how. You want them to clarify and explain details, very clearly describe the how of what happened. You want them to clarify and provide explanations for their actions. And you also want to determine, how do they know what they know? Is it from their direct experience or observation, or is it from secondary sources such as other officers, from the police report, from written statements, or from witnesses? When you use evidence such as reports, photographs, or recordings as needed to refresh the officer's recollection, obtain needed details. I'll discuss this more fully in a few minutes. Don't accept police jargon. Have them define and describe it with enough detail so that someone with no knowledge about police work would clearly understand what they're communicating. You may assume and understand it because of your familiarity with police jargon and procedure. That's often a deficiency in some police internal affairs investigations that you read about. The internal affairs investigator knows what the jargon is, and they don't probe beyond that. Also, don't use leading or suggestive questions. That's one of the primary failing of bad internal affairs investigations that you read about in the news. So next slide, please. So after you obtain that open-ended narrative from the officer, you then want to get details of the officer's actions, the actions of other officers, the actions of civilians. You want not a conclusion or summary. You want them to slow it down and look at it as a film. You want to get a frame-by-frame breakdown. If there are any gaps there, you want to find out why they're there. And is the reason for that gap credible? If the officer says they weren't paying attention because they were looking at something else, we need to assess, is that consistent with their training and procedures and practices? Is that statement credible? You want to determine the why for the officer's action. And this is critical when you're evaluating their motive and justification, their understanding of and adherence to regulations. It can ID deficiencies in training, supervision, or equipment. For instance, the officer may say, this is what my field training officer instructed me to do. Or this is what my supervisor expects. Or my supervisor has approved this in the past. In force cases, don't accept boilerplate descriptions of actions. Ask for a demonstration, for instance, and describe what the officer is doing for the audio recording. If the civilian had injuries, you want the officer to describe the civilian's physical condition at the start and the end of the encounter. You want to determine, is the injury consistent with the force the officer claims was used? Similarly, if the officer is injured, does the extent of their injury conflict with the description of the force they claim the civilian used? For instance, if they say they were struck in the face with a fist, is there swelling or bruising that would be consistent with that type of blow? You also want to ask them if they sustained any similar injuries in the past. You want to try and obtain documentation for the injuries by asking them to sign a medical release. You should end the interview as you typically would with any interview by saying something along the lines of, is there anything you want to add? Is there anything you think I should have asked but didn't? If you think of something you want to add, please contact me. You always want to leave the door open for anyone to get back to you if they recall something after the interview. Next slide, please. So I mentioned this questioning officers about how they know what they know. This is something you may want to ask at the beginning of the interview or closer to the end. It's important because intervening events and sources of information affect someone's recollection of an incident. So you want to find out if before they wrote a report or a statement, did they review any videos, read documents, other evidence, talk to any other officers before they wrote that report. You want to find out when, how, and to what extent they reviewed any of those materials. You also want to find out when and how they learned about the matter under investigation, the complaint, or that they were going to be interviewed. Did you discuss it with anyone, excluding their attorney? Did they receive information from anyone about the investigation, about previous interviews, questions asked or answers given? Did they review any documents, videos, or other evidence before the interview? And if so, you want to ask them when and how. So next slide, please. So now we're going to talk about reviewing some of the evidence with the officer during the interview. So I recommend you treat officers as you would any other witness regarding giving them access to evidence prior to conducting substantive questioning, and that is you disclose and review evidence such as videos or documents only after obtaining an open-ended narrative and all the follow-up questioning you feel you need to do. For documents, you want to establish whether the officer is familiar with it. If so, when did they first review it? How did they review it? When did they last review it? Find out if they played a creation of that document, played a role in the creation of the document. So when was it created? What was it based on? Was it notes, videos, accounts of other officers? Were there any previous versions of that report or document? And who read it, viewed it, approved it? And were any changes made after those individuals reviewed or approved it? Next slide, please. So now we're going to talk about video and audio evidence. Video is very much present in our investigations. This would include their officer's own body-worn camera videos from other officers, from CCTV cameras, news footage, videos posted online. As I said, with any other type of evidence, you disclose and review it after you do the substantive part of your questioning. Before playing a video or audio recording, you want to determine whether the officer is familiar with it, and if so, how. Obtain details of the officer's viewing of the recording. When did they first see or hear it? How many times have they reviewed it? And at what speed have they viewed it? Has it been in slow motion? Has it been frame by frame? Did they review the version you're going to show them, or perhaps an enhanced version? Sometimes an officer's union or attorney will get a video that's publicly accessible enhanced. And so they may have seen something you have not had access to. Ask them when they last reviewed it. Who was present particularly when they first reviewed it? Because those people are potential witnesses to the officer's initial reaction to the interview. Did they discuss it with anyone else? Did viewing the video refresh their recollection? And if so, how did it refresh it? Was the video inconsistent with their recollection or knowledge? Was the video incomplete or inaccurate? And if so, how? Now, without expert review, don't assume that the video you're showing is 100% accurate. Videos can be very limited in what they show, and there's a lot of literature on this. So don't assume that the video you have is the absolute truth. Next slide, please. So when you're playing the video or audio evidence for the officer, you want them to confirm their own actions and statements. You want to ask, is that you? Is that your voice? It's important for establishing who said and did specific things that are seen and heard on the recording. As you go through the video, you want to note the time in the video that you're stopping it, that you're asking the officer about. So when you listen to that audio recording, you know what's being referred to. You want the officer to confirm other officers' actions and statements. Ask them, who is the officer doing or saying blank? You want them to describe and clarify their actions that are shown in the video. You want to explore why they said and did what is seen and heard on the recording. If they muted or turned off their body-worn camera or some other type of recording, determine why. You want to note and explore the inconsistencies, if any, between what's seen or heard on the recording and the officer's account, what they're telling you during the interview, what they may have stated verbally or in writing previously. And then you want to explore what's the reason for the inconsistency. Don't be judgmental. Do not assume that an inconsistency indicates the officer is lying. There are a lot of reasons for inconsistencies. You want to gather sufficient information so you can determine and evaluate whether that inconsistency is credible. Lastly, you want to ask the officer if they know of or have seen any video or audio recordings you do not possess. It's possible something could be out there, and it's very important for you to know about all relevant evidence. Next slide, please. So some special issues. Officers whose accounts are inconsistent with policies or training. So you want to be certain to ask them about their understanding of rules and or training. Don't assume that their understanding of their knowledge is what the rules say. You want to ask about their usual or past practice. And if there's a deviation from usual or past practice in this incident, you want to ask the officer to explain or justify why they've deviated what is typically done, what they've done in the past. Next slide, please. Another issue is officers who don't remember. So you want to establish how common or uncommon the incident you're questioning them about is. So if they do 2 or 3 traffic stops a day and 2 months have elapsed since the incident, that's a common occurrence. They're not that likely to recall that specific traffic stop. They would be more likely to recall an uncommon incident, something that has something unusual or unique about it, the location, the situation, parties present, subsequent court appearances or interviews or something else that's happened in the intervening period that would remind them of this incident. You want to consider whether this is something they should be expected to remember, whether that would be reasonable. You can ask them, is this something you would remember if it happened? They may answer no if it's a common occurrence. If they say, yes, I would remember it if it happened or if I said it, it's then more difficult for them to deny it later on. And as I said, you also want to ask if they are reminded of the incident because of having to go to court, another interview, press attention, social media attention. You want to establish the gap in time between the incident and when the officer learned of the complaint or the investigation or that they were going to be interviewed. That should be a triggering event for them to perhaps think back to the incident. And you want to ask if they recall other incidents or runs they were dispatched to on the day of the incident you're investigating. Next slide, please. So lastly here, we're going to talk about officers who are not cooperative. We hope this doesn't happen. Unfortunately, it does. So you want to try and determine why are they being uncooperative. It could be because of a lack of or misunderstanding of your process. Could be because they're hostile to the process. Could be because they're trying to limit the information they provide or stymie the investigation. For instance, by trying to compartmentalize their answers, refusing to give a narrative, saying they'll only answer specific questions. So based on the reason, you may give a soft response or a harder response. The soft response would be you explain the process to them. Explain it's an opportunity for you to present your side of the story. Why it's important that you do a thorough investigation to ensure there's a fair process. Tell them something along the lines of the complainant had an opportunity to present their side. I want to hear what you have to say. Let them know they'll have time at the end of the interview to provide additional information, or if it's allowed for the rep to ask them follow-up questions. This can be especially important if you have a newer officer who may be nervous, may not feel they're going to provide all the information in the answers they give. The hard response would be you explain the consequences for them not complying. You cite the regulations, you cite the possibility of discipline, you can order compliance, particularly where refusal constitutes a violation of regulations. There's an example of this in the handout materials from the NYPD CCRB, where they typically will order an officer to respond, and if they don't, they can be immediately suspended. So with that, I think we should be ready for questions.
Great. Thank you, John and Jason, for an incredibly detailed and informative presentation. We do have some time for some questions, and just as a reminder, if you have a question, please feel free to jot it down in the chat session and then send it to the presentation organizer. The first question we have is, if you are an external civilian oversight agency and there are compelled statements in your investigative file, shouldn't you rely on prosecutors to clean the files of Garrity statements and evidence derived from them, rather than trying to clean the file yourself?
That's a great question. This is John. Having been on both sides of that equation, I think that it's a two-part process. Now, on the one hand, you should be aware that Federal Department of Justice advises the departments that they oversee or do collaborative reform with that it is best practice for the investigating agency, like the Civilian Oversight Organization, to make sure that those compelled statements are kept in a separate place away from the other statements in the file. So if you're an agency that's under federal oversight or has been in the past, be aware that there are plenty of people out there that are expecting you to do that. One of the reasons that they suggest that is that it makes it so much easier for prosecutors to then double check the work if the compelled statements have clear invocations of the Fifth Amendment right, as I was talking about before, and that happens at the beginning of the interview, and that it's well memorialized by recording the interview, and that the statement is kept in a separate place. Now, there's a lot more work that a prosecutor would have to do in addition to just making sure they set aside that statement. They also have to figure out whether there's any other material that was found or discovered in the investigation that was only discovered because of the compelled statement. And so they definitely will be putting together what they call a clean team and a dirty team. One team of prosecutors who will look at the whole file and make sure they separated all that stuff out, and another team of prosecutors who will only see the clean material that's not subject to Garrity. So the short answer to your question is, well, it is going to require both of you to work hard on making sure that that material is separated out. So you should be prepared to do your part by getting clean, clear invocations and storing them separately.
Thank you, John. The next question we have is, if your process is not included, if your process is not included in the department's union contract and the chief does not provide the officer with Garrity, what would be your suggestion on an alternative method to obtain answers to your questions for your independent investigation?
Well, I'm not sure I completely followed the question, but if the question is, your chief hasn't ordered the officer to come talk to the Civilian Oversight Agency, then I think you should, as a policy matter, make sure that in your local government agency, not just your oversight agency, but in your city or county as a whole, that you make sure that policymakers create a rule that makes officers talk to you, that requires them to talk to the oversight agency. In my opinion, there is no reason that an agency should, the employing agency, the police agency, should allow their officers to not talk to the civilian oversight group. So you need to have a written rule about that. Some agencies have a subpoena rule. Say, often you'll see that in the city charter, like in Los Angeles and San Francisco. There are sometimes local rules written by a police commission. It could be a city council drafted ordinance locally. So you've got a lot of different options, usually in most places, about how to create the rule. You should definitely make sure that that rule is created so it's clear that it is a condition of employment that the officers come talk to the Civilian Oversight Agency. I hope that answers the question. I think that went there. Feel free to contact me at the email or phone number you see on the screen if I didn't get your question quite right.
Thank you, John. And for Jason, what is the frequency with which you should show and question officers about video of incidents or aspects thereof regardless of the source?
I think that depends on what you're asking the officer about and where the investigation is going. If it's an officer who is in the video and you need to know what they did, then you probably want to show it to them. If it's an officer who you have a full statement from and you may not want to disclose what's on the video because that can be transmitted to other officers, you may want to withhold it. It really depends on the import of that particular officer's statement and the potential effect that showing the video can have on them. If there are inconsistencies between what they say and what's in the video, well, you need to resolve those inconsistencies. And so you may want to show them perhaps the relevant portions of the interview involving their actions or their statements. Typically with a named officer, an officer subject to discipline who was accused of misconduct, I would show them most, if not all, of the interviews. Sometimes you fast forward through things where there's nothing being said if they're just waiting for a patrol wagon. But you want to be certain to give the officer an opportunity to explain what's in the video, if that's a significant part of your case, to comment on it, to dispute it, so you can resolve any inconsistencies.
Thank you, Jason. And for either one of you, during the interview process, how should you deal with union reps who call numerous timeouts and consults with the member to discuss your question outside of the room, then come back and the member gives an answer you know the union rep gave him or her?
Well, I can give you my practice. John, you want to give a legal perspective on that?
Well, why don't you go first, Jason?
Well, in San Francisco, we could compel the officer to answer the question, and they were allowed to take a break for personal necessities. I typically did not allow them to take a break to discuss the answer the officer was going to give. I would say, answer the question first. There were times when the officer and the representative would simply get up and walk out, and I would note that for the record, and I think that sometimes we can consider that a failure to comply. Generally, the rules in California and the rules we were operating in San Francisco mandated that officers needed to be allowed to take reasonable breaks for personal necessities. So if the interview had been going for an hour and the officer said, I need a break for personal necessity, it's hard to say no, but I would not allow them to just go out so they could confer about what kind of response they're going to give. And if that did happen, I would note it very clearly on the record, and I think that would go to the officer's credibility.
Yeah, this is John. I agree with everything Jason just said. You know, I'd say too that at least in California, it is a general rule of thumb that if you are taking a deposition or if you're doing testimony in court, breaks between the question and the answer wouldn't be allowed. So a break is generally allowed in those kinds of litigation contexts only after the answer is given. So you have a question, then an answer, then a break. And I think that's a good practice to follow. You might want to find out whether there's some authority in your state or your area about that that's commonly used in litigation context. Your legal advisor could probably tell you about that. And if you're able to point to it, that might help you a little bit in maintaining that rule. But just because someone has the Weingarten right to have a representative does not mean that they have a right to take a break between each question and their answer. And I would just make that a practice you don't allow in your jurisdiction. And as Jason points out, if people defy your instructions, especially if you've given them clearly at the beginning in your advisements, then you can use that as a factor to reduce the officer's credibility in the eyes of whoever the decision maker might be.
Thank you, John and Jason. Unfortunately, that'll probably have to be our last question for today because of time. But there are a couple of you who have asked how you can get a copy of the PowerPoint presentation. It is included in the handouts, but we will also send it out to all of you just to make sure that you all have a copy. There's a lot of important detail in there, and so I'm sure that many of you would like to see that. If you do have a question that was not answered today, there will be an opportunity in the survey to type that question in, and it'll be sent on to John and Jason, or their contact information is on the screen now, and you can also contact them directly. And so I want to thank our presenters and all of you again for attending today's session and for taking a moment to complete the online survey that will be sent out shortly. We are currently developing the next webinar in our series, so please make sure to check the NACOLE website for details as they become available. Please also take a moment to look at the information on our upcoming regional training and networking events in Oakland, California on May 3rd and Nashville, Tennessee on May 17th. And of course, our 25th annual conference, which will be taking place in Detroit, Michigan, September 22nd through the 26th of this year. Spots are limited, and so we suggest you take a moment to register and make sure you are part of these training opportunities. Thank you to everyone, and we look forward to having you at our next training event.